All right. Indictment. The examination of a witness before the grand jury is a proceeding, quote unquote, within the meaning of the provision to the General Appropriation Act of 1903 that no person shall be prosecuted on account of anything which he may testify in any proceeding under the antitrust law. The word should receive as wide a construction as is necessary to protect the witness in his disclosures. The interdiction of the Fifth Amendment operates only where a witness is asked to incriminate himself and does not apply if the criminality is taken away. A witness is not excused from testifying before a grand jury under a statute which provides for immunity, because he may not be able, if subsequently indicted, to procure the evidence necessary to maintain his plea. The law takes no account of the practical difficulty which a party may have in procuring his testimony. A witness cannot refuse to testify before a federal grand jury in face of a federal statute granting immunity from prosecution as to matters sworn to, because the immunity does not extend to prosecutions in a state court. In granting immunity, the only danger to be guarded against is one within the same jurisdiction and under the same sovereignty. The benefits of the Fifth Amendment are exclusively for a witness compelled to testify against himself in a criminal case, and he cannot set them up on behalf of any other person or individual, or of a corporation of which he is an officer or employee. A witness who cannot avail himself of the Fifth Amendment as to oral testimony because of a statute granting him immunity from prosecution cannot set it up as against the production of books and papers, as the same statute would equally grant him immunity in respect to matters provided thereby, or matters proved thereby. Pardon me. The search and seizure clause of the Fourth Amendment is not intended to interfere with the power of courts to compel the production upon a trial of documentary evidence through a subpoena. Ducis tectum. While an individual may lawfully refuse to answer incriminating questions unless protected by an immunity statute, a corporation is a creature of the state. This is great. And there is a reserved right in the legislature to investigate its contracts and find out whether it has exceeded its powers. There is a clear distinction between an individual and a corporation, and the latter, being a creature of the state, has not the constitutional right to refuse to submit its books and papers for an examination at the suit of the state, and an officer of the corporation which is charged with criminal violation of a statute cannot plead the criminality of the corporation as a refusal to produce its books. Franchises of a corporation chartered by a state, or so far as they involve questions of interstate commerce, exercised in subordination to the power of Congress to regulate such commerce. And while Congress may not have general visitorial power over state corporations, its power is vindication of its own laws, are the same as if the corporation had been created by an act of Congress. You can't own Congress, buddy. Raffle. Super fucked. See, it helps to actually read the code. The corporation is but an association of individuals with a distinct name and legal entity, and in organizing itself as a collective body, it waives no appropriate constitutional immunities, and although it cannot refuse to produce its books and papers, it is entitled to immunity under the Fourth Amendment against unreasonable searches and seizures. And where an examination of its books is not authorized by an act of Congress, a subpoena ducis tectum requiring the production of particularly all of its books and papers is as indefensible as a search warrant would be if couched in similar terms. Although subpoena ducis tectum may be too broad in its requisition, where the witness has refused to answer any question or to produce any books or papers, this objection would not go to the validity of the order committing him for contempt. This was an appeal from the final order of the Circuit Court made June 18, 1905, dismissing a writ of habeas corpus and remanding the petitioner Hale to the custody of the marshal. The proceeding originated in a subpoena ducis tectum, commanding Hale to appear before the grand jury at a time and place named, testify and give evidence. Hale versus Hinkle, 1905, not 1906. You fucking history editors. Criminality which lingers over. Well, I guess. Wow. I guess they tried. Did that blog it? I have to read it and see if they changed it. That would suck. Criminality which lingers only as a memory and involves no present danger of prosecution. To put in an extreme case, a man in his boyhood or youth may have committed acts which the law pronounces criminal, but it would never be asserted that he would thereby be made a criminal for life. It is here that the law steps in and says that if the offense be outlawed or pardoned, or if the criminality has been removed by statute, the amendment ceases to apply. The extent of this immunity was fully considered by the court in Councilman versus Hitchcock, 142 U.S. 547, in which the immunity offered by something statute, revision statute section 860, was declared to be insufficient. And the consequence of this decision, an act was passed, applicable testimony before the Interstate Commerce Commission, almost the exact language of the Act of February 25th, 1903, above quoted. This act was declared by the court in Brown versus Walker, where I know that's a fucking big fucking deal, to afford absolute immunity against prosecution for the offense to which the question related and deprive the witness of his constitutional right to refuse to answer. Yeah, that's a big fucking deal. Indeed, the act was passed apparently to meet the declaration. No, God. How did I lose that? Oh, yeah. Declaration, alright. A statutory enactment to be valid must afford absolute immunity against future prosecution for the offense to which the question relates. Wow, hold on, that's great. Indeed, the act was passed, apparently to meet the declaration in Councilman versus Hitchcock, that a statutory enactment, to be valid, must afford absolute immunity against future prosecution for the offense to which the question relates. If the constitutional amendment were unaffected by the immunity statute, it would put it within the power of the witness to be his own judge as to what would tend to incriminate him and what would justify him refusing to answer. Well, to answer almost any question in a criminal case unless it clearly appears that the immunity was not set up in good faith. We need not restate the reasons given in Brown versus Walker with an opinion of the court. So anyways, this is at page 201 US 68. I recommend that you guys read this stuff. This is Hale versus Hankel, the full text. This basically says you have an unlimited right to contract to go about in commerce however you wish, and that they cannot take your constitutional rights away from you whatsoever. It says if you were to be tried on it once, you cannot be tried on them again. It's recognizing that statute is fundamentally opposed to the law of the land. So, and then it gets into middle tenets and maxims, how, man can contract with man, but not with paper, that kind of thing. So, only corporations can contract with corporations, etc. Without answering his opinion is reported in Wharton's criminal pleadings and practice. He says the grand jury have the undoubted right to send for witnesses and have them sworn to give evidence generally, and to found presentments on the evidence of such witnesses. The question here is to whether a witness thus introduced is legally bound to disclose whether a crime has been committed, and also who committed the crime. Corporations can't try man and shit like that. This charge contains a thorough discussion of the whole subject. While presentments have largely fallen into disuse in this country, the practice of grand juries acting upon notice, either of their own knowledge or upon information obtained by them, and incorporating their findings in an indictment still largely obtains wherever doubts there may be with regard to the early English procedure. Practice in this country under the system of public prosecutions, carried on by officers of the state appointed for that purpose, has been entirely settled since the adoption of the Constitution and an lecture delivered by Mr. Justice Wilson of this court, who may be assumed to have known the current practice before the students of the University of Pennsylvania. He says,